Good evening, everybody. Jonathan here. Hope you are all doing well. I'm actually here in Atlanta. It's a beautiful day. It was about 75 degrees, 72 degrees today, and which is really kind of neat. We don't normally get that in February, but we did. I'm real happy about that. I hope wherever you are, the weather is good. We've had some crazy weather this winter, and we'll see if we'll see what happens as far as the rest of the winter goes. Some people think that there's going to be another cold snap. I don't know, but who knows? No guest today. I was going to have somebody, but he could not make it, so we'll have him on next week, hopefully. And we're just going to go ahead and do our normal answering questions. So we have Christina, who is from California. Christina is a regular. I think, Christina, you were not there last week, and we missed you, but hello, I'm glad you were here today. Vince is one of my clients. Good to see him as well. And we will, of course, let me put that banner up there. Where if you want to get a free case evaluation, you can do that there. Okay, so we've got a few questions already. Wow. Okay. Okay, Gary. Okay, so Gary, we just got a favorable decision in your case, which is, it's always good when somebody says I received a healthy direct deposit. And I have not received, and again, I don't like to talk about individual cases, obviously for privacy reasons, but I will just tell you that I have not received the explanation of benefits letter either. But normally, if they send you a big check, that's a good thing, and we should get that fairly soon. The long-term disability carrier, of course, is going to want you to repay them what you received to the extent it was you were also receiving disability for the time you're getting long-term disability. The positive there, by the way, is that you end up paying me nothing. If somebody has long-term disability, you have to pay them back, but you only have to pay them back what you got. You don't pay them money you didn't get. So fees that were paid to me, in essence, get paid by the insurance company. So yeah, I wouldn't do anything until we get that explanation of benefits and we make sure that everything is completely done. But that is, yeah, I saw that. That is a very good sign. And so I think we're like really in the home stretch, and always good to get a healthy deposit into one's bank account. I like that too. So again, bottom line is I would just sit tight for a couple of days. The explanation of benefits letter will be coming in the next week or so. We can go over it and make sure there's nothing that we need to deal with on that. But I think otherwise things are looking pretty good. Okay, we have Stacy, mind yours. Stacy says, thank you for the information. My pleasure, Stacy. I'm happy to do it. Question is, the doctor I was sent for the CT exam did not examine the problem, but focused on my breast augmentation and never about my pain. Made me feel uncomfortable, misunderstood, violated, dismissed. I really think it's going to mess up my case. Can I get a second exam with a different doctor? I don't think you can get a second exam, another exam with a different doctor. What I would tell you is that obviously would be of concern to me as well. So what I would tell you is in a situation like that, I would take extensive notes about what happened. If you're represented, I would make sure your lawyer knows about it. And what I do when I have a situation like this, I've not had one quite like this, but if I have a situation where I feel like the consultative evaluation was really not good, then what I will do is I will ask the judge to give it less weight, and I will submit, my client's notes, or we'll put it into like an affidavit type of form, and that way, if the judge is considering that report, and you can say, he was focused on your breast augmentation, just things that are, sound borderline inappropriate, maybe even not borderline inappropriate, then, the judge has the right to basically say, I'm going to give that very little weight. You theoretically could ask for another consultative. I would tell you that my experience with physical consultatives is they're kind of a waste of time. So I don't know that I would really go that direction. I think it's, if you've got good records otherwise, maybe the better strategy to do would be just to try to get that one deemed, not controlling or not very valuable, and that might might help you as far as that's concerned. So, but that's what I would do. But if you have a lawyer, I would talk to your lawyer about it. But you are absolutely right to be concerned about inappropriate behavior by a consultative doctor, and make notes of that, but you don't want to let that go. And I think, again, I would want to get that into the record. There's a state form. You can have a statement form by a claimant. You can submit that, or you can submit it as an affidavit and just let everybody know. So that way it's part of the file, and that everybody knows that this is inappropriate. Quite frankly, I think Social Security needs to be aware of it. so that they can take a look at that doctor to see should he be conducting consultative evaluations. All right, KR says, recently approved for years of back pay. That's great. Have a few months of trial work period. Do not understand the SGA TWP. Don't know how it's going to affect my case. The judge knew I was working minimally and it was hard. Okay, so I think that, and let's pull that up. Let me pull up the actual numbers here so you can see them for trial work period. And let me just move this window over here so I can see it a little better. I'm going to show you all. I'm going to show you all the page. I have like now 3 monitors. I don't know why I have 3 monitors, but I do because I'm working on briefs. So I like to have a bunch of stuff open. So it's probably a little bit of overkill, but let's go ahead and share the screen so you can see what I'm talking about. Okay, so basically what we have here is substantial gainful activity and trial work period. So a trial work period, basically as of the date you're found disabled, and the table will change, but in 2025, it is $1,160. So if you have, and if 2024 is 1,110, 2023 was lower than that. So as of the date of your onset of your disability, you're allowed 9 trial work period months in any 5-year period of time, and it rolls off. So, something that you used up 4 or 5 years ago, when you hit that 5-year anniversary, it rolls off. So you can have up to 9 of these. And obviously, if you were working and you're using those up before you're disabled, theoretically, you could be approved and have no trial work period months left at all. And it's hard because they don't give you any way to calculate it live. You have to just, really have to just kind of assume you have to do your own calculations, really. So, as of your date of your onset, and of course you take away the 5-month waiting period, look at your earnings, and it's earnings by month, by calendar month, and you can look at the trial work period table. Let me see if you guys can see that. That's a different screen. Let's go to a different. I'll show you that here. Let me show you the trial work period screen. Okay, here we go. All right, so here's and I'm gonna put the link in the notes here. So if you go to the trial work period table, all right, and you will see that in 2022 it was $970, 2023 $1,050, 2024 $1,110, 2025 $1,160. So if you have 9 of those. However, the SGA table is a different table. SGA, which really represents what Social Security considers work, is a different set of numbers. And so let's go ahead and show you that. And in 2024 is 1,550. I think it was 1,510 in 2023, 1,620 in 2025. So if you're over trial work but under SGA, you're not considered to be working, but you don't have your trial work period months. And I realize it's very confusing why they have these different numbers. But the bottom line here is that if you keep your earnings below SGA, you will be okay. Now, obviously, if you go over the trial work period months, when you're within your trial work period 9 months, you get your benefit plus you get your whatever you're earning. Once you use those 9 months up, then they stop paying you your benefit, but you keep your earning, but you not going over SGA. So the key here is big picture, keep it below SGA if you can. And if you can do a spreadsheet that looks at your gross earnings by calendar month, and it's when you receive the money, as of the date of onset, you can see, if you look at the trial work period table, you can see where you used up your trial work period months. But I don't know of any place you can go to ask that. You have to do your own calculations. And then look at your SGA table. Have you been over SGA? And if you use up your trial work period months and you go over SGA, you're now overpaid. That's not a good place to be. So again, you just have to really look at this very closely and kind of study it. But look at those two tables. But again, big picture, you want to be below SGA, substantial gainful activity, because Social Security defines disability as being unable to engage in substantial work, SGA, due to a diagnosed medical problem. So as long as you're under SGA, you can still be found disabled. And theoretically, that means, if SGA in 2025 is 1,620, you could have earnings, gross earnings, before taxes, of $1,619 for every month in 2025 and not be over SGA and theoretically be found disabled. Now, obviously, a judge is going to look at that, kind of with kind of a jaundiced eye, like, why are you right at the number? But theoretically, you're not earning over SGA. You are not working for Social Security purposes. So it is very confusing. They make it confusing. It would be really nice if there was some sort of a utility that you could see in real time. Okay, you have 3 more trial work period months left, and it would explain that, but there is no such thing. So you just have to kind of do the numbers yourself. But again, stay under SGA, and you should be hopefully okay. Rodney is one of our former clients. Hello, Rodney. And I got your email today. I told you what you needed was a copy of the decision. I think Susan should have that. Susan's another attorney that I work with in my office, and she should be able to give that to you, which I think is what you needed. Okay, let me go ahead and stop the share here. Sarah D says, I'm in the recon phase of my SSDI, and I was working part-time and injured my knee and now starting a workers' comp case. How will this affect my case and any offsets? Workers' comp and Social Security do not play well together. And what I mean by that is that if you are getting workers' comp benefits, which are going to be typically more than your Social Security, it offsets your Social Security dollar for dollar. So let's say your Social Security, you were approved for it, and your monthly benefit, let's just pick a number, $1,500 a month, but your workers' comp was $2,000 a month. Every month you are eligible for that $2,000, you don't get your Social Security. The real problem is if you're trying to find a representative, no one's going to take your case because there's no past due benefits or offset. So workers' comp is it's a real issue. Somebody contacts me and they're have an active workers' comp case, even if they have a really strong argument for disability, as long as they're getting comp benefits, I can't take their case because there's no way for me to get paid. Now, once the case settles, as long as you have language in that settlement that treats the lump sum as if it was being paid out over your expected lifespan, then you can that would allow you to get an attorney. You could go ahead and you'd get your Social Security as well. But I think that if you're going to pursue a comp case, if you've got a Social Security attorney, let the attorney know, and let your comp attorney know that you're also pursuing Social Security, and see if you can figure out which one makes the most sense for you. It may be that the comp case is worth more money to you than the Social Security case. There's also, and I'm not going to go into great detail about this, but there's also a potential problem with something called a Medicare offset. And basically what that means is that Medicare does not want people using Medicare or Social Security to pay for medical treatment that was supposed to be paid for by the insurance company for your workers' comp. So you have to do something called a Medicare set-aside in many cases if you have an active Social Security case. So it adds a whole layer of complications is really what it boils down to. So again, if you've got attorneys with these things, I would talk to your attorneys, but be aware that there is going to be an offset, and it's it's not a good thing, as far as the Social Security part of it. Okay, so Biol says, I heard from a user online who claimed to work at Social Security. They have something called a fast track, which is true, where people with serious illnesses are pushed through faster than others with less limiting illnesses. Is this true? If you know about this, you can enlighten me on. Yes, there's a number of different programs that are designed to fast track cases. Social Security, believe it or not, does want to get people paid who are clearly disabled. So there is something called a quick disability determination process. There, of course, is the compassionate allowance. There is this new emergency ruling that basically says that in certain cases, an adjudicator can get a case approved without going through medical review. But yes, they are fast tracking really, really strong cases, but it's got to be more likely than not a listing level case. So it's got to be really, really serious. My guess is you're going to see people over 50 with really bad physical problems are the ones you're going to get fast tracked, or you may see people that have terminal illnesses like cancer or certain diseases; those get fast tracked. So that is all very true. But the quick disability determination is the technical name for it, and that is what they're supposed to be looking for. And what I do when I have a case that I think should be fast tracked, I've got a couple right now of people with stage 4 cancer, and so I'm actually following these cases. I'm not going to get paid on them because they'll get approved within the 5 months. But that's just sometimes you got to do it, and most attorneys I know do that as kind of a pro bono type of thing. But those are the cases that I would put in the application. Please review this case for quick disability determination. Put in the fast track, it's listing level, compassionate allowance, get it approved early. And I've seen cases approved within a matter of weeks. So yeah, I think that's what, but it's got to be a really, really strong case, either a really serious, life limiting illness or a clear listing level case. If you've got a case with multiple issues, you've got some back issues and you're diabetic and you've got kidney disease and you've got, I don't know, something else, you've got, blood clots. It's probably not going to be something that can be fast tracked because, no one of those things may be enough to put you over the hurdle. But, when you look them all together, the combined effect would so reduce your functional capacity, you wouldn't be able to work. That is not the kind of case that's going to be fast tracked. It's going to be typically the more listing level type of cases, I believe. Sarah, this is the person with a workers' comp, chronic anemia will not support. Okay, so she's asking a second question is that you've got chronic anemia, but your hematologist will not support your Social Security. Should you get a new doctor? I would honestly look at the medical records and see if the medical records, document a significant problem. I'm less concerned than I used to be about getting a doctor to fill out forms for me. A lot of doctors won't do it. I still win a lot of cases. I think that, as long as the medical records support your argument, you should probably be okay. You should probably be okay. Even I hate to tell somebody to, change a doctor that's giving them good treatment. All right. No Sky says engine starting, which is obviously our live stream tonight. He is a loyal listener and a friend. Prepper Joe, is it better to do a CDR online or by mail? I kind of like to do them online. I mean, I just think that Social Security tends to lose papers. And so you do it online, I think it's more likely it's going to get processed appropriately. So I would say, as a rule, anything you can do online, you should do online. TEM Jr., I had a general medical exam, then a psych exam, one in January and February. How long do I get the results in Texas? The results, the report is already in. If you have an attorney, your attorney can go into your electronic folder and download the reports for you to see, but the reports are in. Now, as far as getting a decision, that could be, a month or two, it could be 6 months. It just depends on how the rest of the file is being put together. Texas happens to be really slow. You've already gone on for about a year and a half to 2 years. It's going to it takes a long time. It really does. It really takes a long time. Trish Ward says, hello, Jonathan. Hello, Trish. How are you doing? Prepper Joseph, that's short form to fill out that get damaged. So I do the CDR online. Well, yeah, I think that doing it online, I think makes a lot of sense. In my opinion, I think it's a good way to do it. Okay, here, let's see what we got here. Martini Shot says, hello, Martini Shot. Vince, on my approval letter, and Vince is a client of mine, says specific date when my payments are supposed to start. They generally pay on time. I think that's been my experience. They're usually pretty good about that. GJH, already on disability. Well, I assume you're probably here because you want to know more about the continuing reviews, but I'm glad you're on. You've gone through a big part of it because getting on is difficult. But hopefully you will not have any issues with reviews because that's very stressful. And really one of the big issues with reviews is there's really no way to get an attorney involved in it, because if you choose to have benefits continue while you're being reviewed, no past due benefits. If you choose to have not collect benefits while you're appealing, you have no money coming in. So it's a real difficult situation. So hopefully you don't have to deal with that. Scott H says, how long after speaking to a medical examiner does it take to get a determination? I think you mean a consultative doctor. I think it's going to just depend on, how fast your file can be put together. There's no specific amount of time. I mean, you've heard, the gentleman from Texas said he's been waiting 1.5 to 2 years. And so, it's a numbers game. It's just they're really busy, but there's no specific amount of time. It just really depends on when they get the file put together and somebody looks at it. Normally, an initial application is going to be about 8 to 12 months, and a recon is going to be 7 to 11 months. But those are very general numbers. It could be longer. Martini Shot says, if I was on state disability since August and applied for SSDI with the onset date going back to August, will I need to reimburse my state? Well, if I win, or SSDI will my payment to prevent double pay? I don't know. I think, if I'm not mistaken, there is an offset. I believe the offset would be from Social Security, but I don't know. And I don't want to give you wrong information. I know California has a state disability program. If anybody here is in California has dealt with the state disability and Social Security, they may have an answer for you, but I honestly do not know. Terry Clemens says a 50% rate. Terry, you got me confused. Let me see if you had asked me something before. Let's see here. I don't see it, so I'm not sure what you're asking me there, Terry. Okay. Tony Snell says, I found a sedentary job. And sedentary by Social Security terms means you're sitting for 6 out of 8 hours and standing up to 2 hours in a day. So for Social Security purposes, standing 2 hours a day still makes it sedentary. And lifting 5 pounds frequently, 10 pounds on occasion. That's what sedentary is defined by Social Security. Other entities may define it differently. I'm going to work as long as I can. Back still hurts, but I'm going to hopefully hang on to beyond 55. And obviously, if you get to 55, you're disabled even if you could do light work. At 50 to 54 and 364 days, you're disabled even if you could do a sedentary job. But I would agree with you, Tony, it's much better to work than not to work. So if you can hang on and work, I would tell you definitely to do that. Stay on this channel from Alameda Bay, Northern California. Thank you. Thank you very much. I appreciate that. Nice is your handle. Thank you very much. From Northern California. Very good. Okay. Mark is one of my clients. We're at the bottom of the ninth. Okay. And then let's see. The designated hitter is coming to the plate. Glad you're on the team. Glad to be on the team, Mark. Designated hitter. Okay. Pinch hitter, whatever. And I'm not really a pinch hitter. I've been in the game for a while. But yeah, we're getting close. I think we have a hearing date, but we're getting close. So hopefully we'll be hearing some good news soon. Terry says, what's my chance? I'll be 49. And I think you're the one you got a 50. I'm assuming you said you have a judge of the 50% approval rate. Again, your age is only one part of it. Obviously, it is more difficult to get approved when you are under 50, but 49 is pretty close to 50. So you're on the high end of your 40s, and so even though the grids don't apply, I think judges do realize just inherently that a person who's 49 who's got medical problems is going to have a harder time finding a job than a person who's 29 or 39. Does that mean you get approved? Doesn't mean that. It just means that you're probably in a better position than you would be if you were 29. So hopefully the medical is really strong and that you've got a good argument either under the listings or under a functional capacity argument that your reliability, dependability at work is so suspect because of the medical issues, you would not be very reliable. T. Love says, hello and good evening. Hello. Chan Tet. I do agree the examine doctor about 5 minutes to determine disability or not. Okay. I'm thinking what you're asking me is if you go to a consultative evaluation that lasts 5 or 10 minutes Is that a valid, consultative? I think obviously no, it's not. And again, this is where you really want to write down exactly what happened. The woman earlier talked about that, she felt very uncomfortable with the doctor's questions. She didn't talk about physical contact, but she felt uncomfortable with his questions and what he seemed to be focused on. And yeah, I think that, these kind of really, really, really small, low time period or very short disability evaluations are really not worth a whole heck of a lot. I think most judges know that. Jennifer, one of my clients, waiting on recon since May of 24. How long is it taking? So if the new emergency memo can go back to the doctors monthly. Now, I don't think going back to the doctors delays it. I mean, I think that, May of 24. So now we're not quite at a year. And this is unfortunately very typical. So I would tell you that a recon decision, can take up to a year. It's ridiculous. And I would tell you that once you get beyond 5 or 6 months, it might be time to reach out to your U.S. Senator and ask for a congressional inquiry and see if that might move things along. I have a case I'm trying tomorrow where my client did exactly that. She asked her representative in this case, and that documentation and the response is in the file. So they read it and they take that very seriously. You got to be a squeaky wheel. But I think that may be, we're getting close. Obviously, we're getting close to that year, but it doesn't mean it has to be a year. It just means that's pretty typical. For your free case evaluation, the video call to be connected by email, what would you like to send for the evaluation? I do most of the time, I do it by telephone call or email. So the first thing I ask people if they're doing a case evaluation would be to give me a lot of detail about their case. And specifically, what I'd like to know is why you think you're disabled, how old you are, where do you live, have you filed before, you have another attorney in the case, those kind of things, what type of work you've done in the past. And again, the main thing is why you think you're disabled. What kind of medical condition do you have? And that will tell me a good bit about, what, as a starting point for a conversation. And then depending on what you say, I may have more, sometimes I go back and forth a few times. And I have called a couple of people, Madeline, who's on here sometimes, is one of my call screeners, paralegal in my office. And Madeline will call people when I can't get to them. I'm in hearings or whatever. And so a lot of times it'll be Madeline who'll call and she'll take the information. And then, you may get a call from me or, Madeline may, open it. And so we'll go from there. But yeah, it's just the more information, the better. If you've got MRIs or other tests, that would be something that would be very helpful as well. Okay. Annie says, I've been on disability in Wyoming. My 3-year evaluation is coming up in April. Haven't received any letters. Do you think this will be delayed? Thanks for everything. Yeah, I don't think that because it says 3 years, it's got to be 3 years. It could be 4 years or 5 years or never. This is aspirational in many respects that they're going to give you a 3-year review. Now, I do think that we're going to see more effort by Social Security to try to use the CDRs to cut people off. I think that is, if you saw, I did a series of videos on a YouTube channel about, and they were entitled, will Elon Musk, his intent to destroy Social Security disability? And I got a ton of views and a lot of comments. And I will tell you, I didn't really offer an opinion so much as to say, this is what I think. I don't think he's all out to destroy it. I think that, in his mind, I think that he's a numbers guy. And so they're looking at a system. I say they, I mean the president and Social Security administrators and people in Congress are looking at it. They have a system that is going to run out of money in 10 years. There are not enough workers to continue to cover all the expenses going out for retirement and disability. They've spent the money. It's not like it's been saved away. So they're looking for ways to reduce the number of people claiming disability benefits. They can't do anything about retirement because it's based on your age. So, they're going to make it, where they're going to really look at it very, very closely. I think that a logical place for them to go is the CDRs, to try to get more people who are on benefits, especially younger people, cut off. Now, that being said, doesn't mean disability is going to disappear. It means you got to be more diligent when you're applying. I think that the role of an attorney is going to be even more valuable because we're going to make sure the files are put together correctly, and you've got to have ongoing medical treatment and documentation of a severe problem. I don't expect this to go away. Look, I've been doing this for a long, long time, and it goes in ebbs and flows. And the reality is, there are people out there, many of whom, I suspect are maybe tuning in tonight, who cannot work. They would love to work, but they can't work. We just have to prove it. And that's my role is to get the evidence to prove it. And judges are independent, at least at this point. And I don't expect that we're going to see a dramatic change in the approval rates. Again, I think they're going to go after they're going to do more CDRs, and the landscape may change somewhat, but we'll adapt. We'll adapt. But if you are disabled, you still should apply. If you absolutely cannot work, and we'll find a way to get you through if you're deserving. And I think that inevitably when they have these situations like this, Social Security or people at the White House or whatever, they start saying we need to cut back. The judges kind of even it out. I think that many of the judges realize that there's a need for the disability program, and they will even it out. And again, I think it's even more reason not to do it on your own. I mean, I don't mean to sound self-serving, but you have one shot for 45 minutes after waiting 2 years. It probably makes sense to have somebody there with you. So anyway, but as far as this question, I don't think that the 3-year is something that you should say is a written in stone, because it's not. Trial work period, no, it starts as of the date of your onset, not the date you were approved. Not when your date you're approved. And No Sky says, here's a video about trial work period. I think you probably saw that earlier, but that's a video about trial work period. Can your caseworker make a decision? In some cases, Sweet Candy 46, yes. There's this new emergency ruling that came out that basically says they can do this in a case where they're going to issue a fully favorable decision, and the access to a medical specialist at the Social Security adjudication office is not there. There's not enough people there. Medical experts, the experienced adjudicator can make that decision. So yes, they can. But normally they go through the process of having a medical expert look at it and offer an opinion. But in some cases that can be bypassed. Justin says, I had a hearing in person in 2014. So you're looking at 10 years ago, 11 years ago. You struggle with the stutter. Hoping the audio hearing this time will be better. I think that, and certainly having a stutter can limit you in terms of the types of jobs you would do. In fact, one of my cases coming up in the next week or so, a person has a severe stutter. It's actually a long COVID issue. It's kind of interesting how that kind of arose from long COVID. But my point is that, there are certain jobs that require, customer service, direct interaction with the public. You could make an argument if you have a bad stutter and you have difficulty with communication, it would be hard for you to do a job where you're, taking orders at a, behind a desk as a clerk someplace, or you're a wait server or something like that. So I think that could be used to eliminate certain jobs if it's documented. And again, you may have to go to a speech therapist or somebody to document the stutter. What about the extended 36-month work period? Okay, what that says is that if you are on disability and you go back to work, it's 30. I don't know if it's exactly 36 months. Let's take a look. I think it's less than that, but let's just see, extended period of eligibility. Okay, it's 36 months. Okay, you're right. I seem to remember it as different, but okay. So basically, if you go back to work and your benefits stop because you've gone back to work, there is a 36-month period of time that basically you can come back to Social Security and say, I was working, I've used up my trial work period months, but now my disability has returned. I'm not able to work anymore. And that will fast track you to get, benefits started again. In some cases, if your earnings go below SGA, they will pay you automatically. Other times they might have to do a, more study, ask for medical records, or even do a hearing. I don't deal with this at all, really, because, you know, statistically, very few people really go back to work and have to deal with this. But most of the time, if somebody's on an extended period of eligibility and they go back to work and then they need to use that, it's automatic. They get their benefits, automatically. So there's really no reason for a lawyer to get involved in it. So I don't really deal with that, but it is a 36-month period. Let me see if I can get you. Here we go. I will send you a link here from the POMS, which is the program's operation manual that explains the extended period of disability. And there you go. There it is. Okay. All right. I think somebody asked, okay, well, I think we've already discussed that one. Big pardon. I have a question for SSI benefits. Can steady till 70 years old, or can you turn? Okay, they will turn it to retirement. I think I understand your question. Social Security will automatically turn your disability case to retirement benefits when you hit full retirement age. That you don't do anything; they just do it automatically. Okay. Jenny, I know you had some difficult circumstances recently. I hope things are better, and I'm glad you're joining us. And again, my thoughts are with you. I know what you've been through has been difficult. So, but thank you for tuning in. Mike Albright, he's 64, filed for disability, several medical issues, can't work. My company's offering me 7 months of severance, a long-term disability policy that affect my claim. No, the severance is not considered earnings because it is not based on work for performance. It's basically like a buyout type of thing. And long-term disability does not offset Social Security. Social Security may offset the long-term disability. So if you collect long-term disability, then later on you're approved for Social Security, you have to pay back the long-term carrier, but it doesn't affect, Social Security does not get offset by long-term disability. And judges do not hold it against you if you're collecting from some other source, like the VA or long-term disability. How long does it take from the process an award letter? After a favorable decision, it's usually within 2 weeks. What happens after you've given the none medical forms they've asked for? Not sure if I understand what you're asking, but once you give them the forms, that realize what's going on behind the scenes is when they send you all these forms, that's to help complete your file. And the adjudicator at the state agency is trying to complete the file with medical records, with statements from third parties, with your statement, with forms like work history, medications lists, things like that. And then once all that's put together, the medical's done, then they send it to a medical consultant in most cases for review, comes back with an opinion there. The adjudicator looks at that along with everything else and makes a decision. And of course, if you get to a hearing, the judge is going to do the same thing, but it's going to be a brand new look at the whole thing. So the forms are just, if you don't fill them out and send them back, that can delay processing your case. I've never heard of people getting dismissed because of it, but I think it will certainly delay things. I think GJH, is responding to Ali Tovar about how long does it take to get processed, the award letter processed. A few weeks is about right. Correct. Okay, this is Stacy, Mind George. We already talked about that. Okay, this is a great question. Hawks fanboy 11. My doctor recommended I get a functional capacity assessment. How influential are those in getting you approved? I think they can make a huge difference because what a functional capacity form does is it translates the medical problems into very specific work limitations. So I think that if the functional capacity evaluation, let's say you're over 50, it could limit you to sedentary work. Well, now you have an argument for the grids. If you're over 55 and it limits you to light work, you can meet the grids. If you're under 50 or even over 50, and it says your functional capacity is less than what would be required by in a sedentary job, that can help your case. I think they're great. If you can get them, they're very comprehensive and they address exactly what Social Security wants to know. and that is your work capacity. Okay. Getting a sworn deposition by my doctors. I don't think you need a sworn deposition. I mean, I think a functional capacity form doesn't have to be notarized, even just signed, can be very helpful. That would be better in my view than a deposition. A deposition, maybe you're using the terminology wrong, is where you literally go to the doctor's office with a court reporter and ask questions to the doctor. It's recorded and typed up and submitted to a court. So it's a transcript of an interview. I'm not sure if that's what you mean. Maybe you mean a sworn statement, but I think a functional capacity evaluation would be even better. Okay, fast track short. Okay, so this guy's pointing out that somebody asked about fast track, and I did a video short about this. Here's the link. QD48. I'm at step 3. I got a call from SSA today, the field office. What does that mean? And thank you. I don't know. I don't really know what that means. It just depends. There's no way to tell what they want. Maybe they want a form. Maybe they want, your bank account information because they want to approve you. I just don't know. If you stop receiving income, can they reconsider giving you the max amount? Do you need a lawyer? Allie, you're gonna have to give me more than that. I don't know what you're asking me. If you stop work, I don't know. If you tell me a little more what you're trying to ask, I'm sorry, I don't understand. Okay. What does expedited case processing for 100% permanent and total veterans really mean? I would say it'll put you ahead by 3 to 5 months. It's supposed to put you in the front of the line, but I would tell you it's going to speed things up at initial recon or hearing by 3 to 5 months, maybe a little longer. But it does make a difference. I would say my veterans are getting hearings, still taking a long time. Instead of 3 years, it's 2 years. Instead of a year and a half, it's, or instead of 2 years, it's a year and a half or a year and 3 months. So it does make a difference. Sarah, you're very welcome. Christina, hello again, Christina. Okay, Stacy is the person who had the consultative doctor that you were very unhappy with the tone of the exam and what the doctor says. Never asked about your pain. Again, these are just reasons why you should make note of what happened and talk to your lawyer about objecting to a judge or Social Security considering the evidence or the record of what was generated from that visit, because it was not an accurate representation of what you're going through. Didn't ask the right questions. Christina says, please do not forget to like this live stream. I agree. Thank you. I understand, Stacy. I mean, this does not sound, in the CE exam, it depends on the judge. It can be very important or it can be not important at all. I think most judges realize that these consultative evaluations, look, they see you for 30, 45 minutes. How does that really compare? How can that compare to treatment records that you've seen your own doctor for 3 or 4 years? It is a factor, but, it depends on the rest of the case. Look, I have a case right now where I tried it a few weeks ago. The judge, actually it's a pretty good judge, did what they call medical interrogatories, sent this out to a doctor who's never seen my client and asked for a functional capacity evaluation, which came back and it hurts my case. And I'm going to object to it. Like, how can you make an assessment about this person's pain level and about, how long she can do X, Y, and Z? You've never met her. I mean, it makes no sense, but it's evidence, and they can unfortunately under Social Security law, they can consider this kind of garbage evidence and use it to deny cases. Doesn't happen a lot, but it could happen. Ms. Crystal, thank you you're welcome, Ms. Crystal. You won your case, receiving great, excellent. Leave me a nice review. But that's excellent. That's what I like to hear, because here's how to leave a review. But yeah, no, that I've mentioned this many times before, but I do this because it needs to be done. And there's just not a lot of good information out there. And so I'd like to, help people understand the process. If they hire me, that's great. If they don't, they do it on their own, they win. That's great too. there's plenty of business out there. I'm plenty busy. So when I hear that somebody's won because of something I did, that's great. That's great. Christina says, do a 5-star review. And don't forget to comment. I think Christina makes a good point. And that is, I sometimes people are nice enough to leave me a nice review, 5 stars, but they don't say anything. You want to say something. I thought his videos were good. I enjoyed the live stream. He's a really good looking guy. I mean, just, logical stuff like that. So just anything you want to say something. Don't leave a 5 stars and don't say anything. Doesn't mean I was approved if I got a call. It doesn't mean that. I can't tell you that because they called you, it means anything. I don't know what they want. They may need to know the correct spelling of your middle name. I mean, it could be something really simple. We don't know. Okay. GJH, keeping up with the new administrative news. I would tell you again, I did this series of videos. It's changing, and I'm going to keep everybody updated as what's happening right now. There's not a lot specifically going on with Social Security disability. That may change, but right now everything is kind of the same. The biggest change was that the commissioner who was appointed acting commissioner after Commissioner O'Malley left shortly after right before the first of the year, a woman named Michelle King, I think, she resigned because she was having a bit of an issue with something going on with the president. And they put this guy, Leland Dudek, in, who many people feel like, had not worked his way up. Now, I was at a meeting, a NOSCR meeting. NOSCR is like a trade organization, national organization, Social Security claimants reps. And the president of NOSCR, a gentleman named David Camp, was there. And David knows Commissioner Dudek and said he's a straight shooter. He's a good guy. Now, we have a permanent commissioner who's going to possibly come in soon when Congress gets around to considering him. And we don't know as much about him. So we'll just have to see. We'll just have to see. The former commissioner, Mr. Commissioner O'Malley, was proactively good in the sense of really helping people, wanting to help people on disability. We're not going to get that. I'm just going to tell you, we're not going to get that. But if we got somebody who's just reasonable and fair, who's going to try to do something about the delays, I'm going to be happy. Blue Z, I have a phone hearing tomorrow. All my doctors fill out their part of the paperwork. I pray the judge grants. I'll be 51, work 35 years, multiple health issues. What is monthly SSDI? Well, the amount of you have supply bank information, not at the hearing. You would do that beforehand, and I would definitely do it for direct deposit purposes. That light behind me is bothering me. It's probably bothering everybody else too. What I'm going to do? I'm going to go ahead and put something up here, and then I'm going to go ahead and zoom in a little bit more because that is bothering me. That's behind me. So give me 1 second here. Let's just look at this, and then I'm going to go ahead and see. I'm going to stop the camera for 1 second, just for 1 second. And I'm going to start it here, and then I'm going to go ahead and let me start it. Okay. Can't do that. I thought I could do it. Okay. Well, we'll go back on. What I was trying to do was go back. There's a, let's see if I can just do anything here. Maybe I can do a little bit there. Okay, there's a little bit better. Okay, so what I was trying to do is, there we go. There's an adjustment I can do on my webcam, but it can't work when there's another application, in which case the live stream software. But it turns out that I do have the ability to change the size of my face in terms of what you're seeing. So maybe it's a little less distracting. That white thing behind me here is a video light. It's called a flapjack light. I use it when I do my videos. I was recording some videos earlier this week, so I had it trained on me. Normally I put it to the side. So more information than you want to know, but that's what that's all about. Okay, at least now I'm not as distracted there. Okay. Amanda says, I was finally approved, but it took years. Really important to keep up with the dates for back pay. Don't forget the dates and reapplying, because that's where you lose the money. Yeah, I think you have to be your own advocate. I would agree with her. And you have to really know the dates that you're asking for disability. You've got to know, what your back pay is, and you got to really look at it. Okay. Biol, I'm a resident rehab facility for dual diagnosis. I'll wait until our complete treatment for submitting, so I submit in rehab. Full inpatient treatment is 90 days. When you say a rehab facility, do you mean physical rehab? Is it mental health? Is it drug addiction? I'm assuming you mean some sort of a physical rehab. Um, I would let them know that you're there now, and then when you finish, I would let them know you finished. You want to make sure that the entire record gets in there. Maybe if you let them know now, let them being Social Security, let them know that you are expected to finish in, you know, May 15th of 2025. And they should get the records at that point. But I think there's no harm in letting them know early that you're in a treatment, a rehab facility. Harold says, I finally talked to an adjudicator. He asked me why I can't drive anymore. He said I would hear in something that's 2 to 3 weeks. Okay, well, I'm glad you finally heard from somebody. That's a good thing. Why you can't drive, you would hear something next 2 or 3 weeks. Take that with a grain of salt. Maybe you will, maybe you won't. Just take it with a grain of salt. Why does Georgia deny so much? I don't think Georgia denies more than a lot of places. I just think that in general, and I've given these numbers before. In fact, the waterfall chart just came out. The new waterfall chart. Let me pull that up. Let's see here. I'll show it to you. I don't think I put that on my website yet, but the waterfall chart it lists all of the approval rates at different levels. And I'm trying to find it. Oh, you know what? I've got it on my. I did download it here. Let me just show you that so you can see what it looks like. Waterfall charts. I've got them for. And here's the one for 2024. Just do that. Okay, so I'm going to share my screen here so you can see this. Well, there we go. Okay, so you can see the waterfall chart. So basically it says here that in 2024, 38%, let me make this a little bit bigger so you can see it. Oop, not getting any bigger. Okay, 38% of initial applications were approved. That's up from what it was the year before. At recon, about 16% of cases were approved. Those people who were denied at initial and appealed, 16%, 1/6 were approved at recon, still very low. At hearing, 51% of cases were approved at hearing, which is about the same as last year. So it's running about the same. So, at initial and recon, unless you're listing level or grid level, you're probably not going to get approved unless you've got something really, really serious going on. I don't think it's unique to a state. There is something I'd seen that looked at every state and the approval rates. Georgia was not among one of the lower ones, but it's pretty much about average. It just depends on it really depends on the medical. What your individual case is like. I don't think it's appropriate or accurate to say any one state is better or worse than others. I think they're all going to make it difficult unless you've got a really strong amount of evidence to win early. And then when you get to a hearing, you have a de novo review by a judge, and you can see 51% of cases at hearings are being approved. Now, those cases were ones that the denial was appealed at initial, denial was appealed at recon, went to a hearing, but 51% of those cases are approved. That's pretty decent. And I'll tell you, about maybe 8 or 9 years ago, it was like 42%. So it's gone up, a pretty significant amount. So that's a positive thing. Nice. Says I'm 62. and I got my SSDI to retirement. Stay in SSDI until full retirement. That's what I would tell you. Stay in SSDI to full retirement because that'll max out what you get. Harold says, yes, he was a person who talked to the adjudicator. Again, take it with a grain of salt, but it's good to be closer to the finish line than the beginning. Amanda, great question. You're getting disability, had a terrible car accident. Sorry to hear that. Severe traumatic brain injury. Will that increase your money? No. Your disability amount is based on what you paid in. Having a more severe condition will not increase the money, unfortunately. That will not. Okay. Let me go ahead and put that over here for your case evaluation. This guy is after me to make sure I do that a lot, so I will do it. Will the VA, with the Social Security use the VA exams, the CMP exams, in lieu of consultative exams? No, because VA standards are different than Social Security standards, and they're not going to use. They'll consider Social Security exams, but they're not going to use them instead of consultatives. Okay. Started SSDI in September 24. The onset of September of 23. Got a letter from Medicare. Okay. There's 25 payments start at the onset date. It's 25 months from the date of your first payment, not the date of onset. So if your onset date was September 3rd, let's say of 23, you don't get paid for September because it's partial month. You don't get paid for October, November, December, January, February. Your first payment is March of 24. Medicare kicks in April of 26. That's how that works. Okay, Lisa Waiters. Hello, Lisa. Have SSD. I started in 23. Now my end date's 25. Was approved for 5 years. Situation. I don't understand when you say your end date. Why is the end date December 25? Can you explain that? I don't understand why there is. I mean, normally a closed period would be, if you got a closed period, it wouldn't be in the future. It would be a closed period up until the current or sometime in the past. So I do not understand why you only got approved for 5 years. Where does that come from? I've never heard of that. I'm not saying it's not true. I just never heard of it. You can look the judge up and see the percentage approval rate. That is correct. How to conduct yourself at a phone appointment. Several people. The people on the line are going to be the judge, obviously, you, your attorney, a hearing reporter who operates recording equipment, and the vocational witness. And if there's a medical doctor, medical examiner will be there too. So it could be up to 6 people total. I would tell you the most important thing at a hearing to do would be, number one, you want to make sure you speak very clearly, that you answer with detail. Don't say not very much, not very far, not too long, just a little bit, 5 minutes, 15 yards, 13 pounds, be specific as you possibly can. 2 hours a day. I have to take a rest break for 30 minutes, 3 times a week, from 2 to, starting at 2 o'clock because of medication side effects, whatever. Be as specific as you can. One thing I would definitely tell you, and I tell my clients this, and sometimes it doesn't always resonate, when the judge talks, you stop talking. There may be a half-second delay. And so if the judge interrupts you to ask a question, don't talk over the judge. Judges don't like that. And you really want to make sure that you are pleasant to the judge, respectful. My feeling is, and I do this myself, if the judge is talking, I stop. As soon as I hear the judge start to say something, I just stop talking. I don't care what I'm doing. Never interrupt the judge. I think that's really important. But realize it could be a little bit of a delay, and the judge can't see you, so you need to be descriptive. You can't say, yeah, it hurts back here. No, it hurts, in my right shoulder, right above the shoulder blade. And the pain is at a 8 on a 10-point scale for at least 3 hours a day. I mean, you want to be very, very specific. And that's the secret, I think, to any disability hearing, especially a phone hearing. Okay, so Stacy said, you missed what I said. So just to go over briefly, Stacy it was one of the first questions, and she said that she went to a consultative physical exam, and the doctor was very interested in her breast augmentation. Didn't ask her about her pain. Didn't ask her about her medical history, but really was talking about her breast augmentation. And my observation, my thought was that was, and she felt uncomfortable, it was inappropriate. And I would say, of course, follow your gut. I would agree with you. That's not appropriate. So what I would do, just again to recap this, is write down everything that happened, as much detail as you possibly can, the exact questions that the doctor asked you, what he said, how you felt, and if you have a lawyer, you put that into a statement form or an affidavit form and get that filed with Social Security as soon as you can. And then when you get to a hearing, your lawyer would basically object to or ask the judge to give the consultative evaluation report little to no weight because the doctor was inappropriate. Now, I would say one caveat to all this is you might want to look at the report. What happens if the report comes back and it's very helpful, very supportive of you? Even if the doctor was a jerk and a creep and it was inappropriate, but if he says, well, I think, this claimant is clearly not able to work, or she's over 55 and, or over 50 or whatever, and she's, could not do even sedentary work, the report may help you. And if it helps you, you might want to just say, let me just swallow this, just say, okay, it's not real, I'm uncomfortable with this, but it helps my case. So I think you just need to look at all those factors. And again, if you have an attorney, your attorney can kind of guide you on this. But, if assuming the report is not helpful or it's neutral or you just don't want the report considered at all, I would, describe what happened and get that filed with Social Security. And so it becomes part of your permanent file. JTLBZ. I see a counselor for anxiety and depression. My primary doctor said he could treat me for it. I don't see it's a good idea or not. I'm not a big fan of primary care doctors treating people for depression and anxiety. That's not their specialty. At the same time, a social worker is not considered an acceptable medical source by Social Security. A psychologist would be, certain types of counselors would be, but a counselor without an advanced degree probably is not going to help you very much if that person is not working under a licensed professional. So I would look to see, and maybe you can continue with the counselor, if the doctor feels that you need medications. But it kind of depends on the credentials of the person you're seeing. But generally speaking, I'm not a big fan of using a medical doctor, internist, to treat mental health problems because I'm not really trained to do that. If you get to a disability for mental health, it could be better than would make a heart attack destroys your heart. You have diabetes. They consider permanent. What would they consider permanent? Okay, big picture here. If you have physical and mental health problems, and the physical problems can help win your case, go with that, because physical problems can be documented. I mean, if you've got a bad heart and you're taking nitroglycerin, and you've got a reduced ejection fraction, you've got stents, and you're on all kind of medications with side effects, that's going to be objective. It's easier for Social Security to say this person really cannot work. Depression, mental health, especially if it improves. It's hard. It's not objective. You can't take an MRI of somebody's brain to see their depression. So if you can focus on something that can be imaged, that is a better way to go. Tara Upshaw. Tara's one. I think. I believe, if I'm not mistaken, Tara's one of my clients or a regular. I can't remember. Sorry, you're one of my clients. I know. So I'm sorry. I've got people. Sometimes they have screen names, and I can't keep up with everybody's screen name. But I believe I remember we communicated back and forth about this. But yes, please hit the like button. Yes, please do. Thank you, Tara. Appreciate it. Okay. Zank filed last year in January for schizoaffective disorder, depression, anxiety, bipolar, mania. 25 got denied. This condition is not severe enough. And then I can adjust to other work. Yeah, that's what they do when they deny you. The problem is your age. At 25, even though mental health conditions can be really debilitating at a young age, you are really, really young, and there's a real bias in Social Security against people really young. Um, it's just very hard to win because probably Congress, looks at Social Security, and they have a problem with people getting approved for mental health anyway. But when they see younger people, they really go crazy with that. So it's going to be an uphill battle. I mean, I just flat out tell you, it's going to be a real uphill battle to win disability for anything that is not terminal illness when you're 25. And mental health, because it's so subjective, it's just going to be really hard. I mean, I don't mean to tell you not to keep trying if you feel you can't work, but it's going to be real tough. Um, do they consider disability permanent with heart? It depends on how severe the heart condition is, what the medications are, and what the likelihood of additional problems would be. But heart problems, many cases do not resolve to 100% function. So usually severe heart problems are pretty good as far as getting an award for long-term, ongoing Social Security disability. Mike Albright. Okay, I think we've already answered Mike's question before. Okay, and Zank is the 25 years old, couldn't get the medical reports. Certainly, if you've been inpatient, that makes a big difference. That can be real helpful. And if you have that, get that. Even then, at 25, it's just going to be real hard. But if you have an inpatient hospitalization, that gives you much better chance. So I would definitely say you appeal and get that to them. Yes. All right. Now, GJH says, don't take unemployment. I'm not so sure I agree with that because I've not had a problem with people saying, I'm ready, willing, and able to try to work. And even some of us who do try to work. So I don't necessarily think taking unemployment is, at one point in time, it was a problem. I don't see it as a problem anymore. Jennifer asks, does Social Security always do CEs? Not always, but a lot of the time. You've done what I suggested, which is reach out to your congressperson. Both have contacted. It'll happen. Hopefully very soon. And the CEs, it just depends on what the adjudicator wants to do. They do them in most cases, but not every single case. Gemini Butterfly filed October 17th of 24. 59-year-old had a stroke in June of 24. Phase 3 of 5. Pneumonia, high blood pressure, and diabetic in North Carolina. I mean, on its face, I think assuming that your stroke has left you with some sort of permanent deficit, that's a winning case. Now, if you completely recovered from your stroke, maybe you have a closed period, from June of 24 to June of 25, if you're recovering. But at 59, all you have to show is you can't do light work and you meet the grid rules. And if you've got a deficit with, let's say, one side of your body where you can't walk and stand for more than a couple hours a day, then you're limited to light work or less, and you win, assuming you've got some issues with transferable skills. So on its face, good case. No Sky points out the Elon Musk video. And we went back and forth on this because, Elon Musk is a polarizing figure, and, he doesn't have control of Social Security, but obviously he's got a lot of influence on what's going on in terms of trying to make the government more efficient. And there is a perception, maybe a little reality, there's some bloat at the top of Social Security. They are going after the bureaucracy with a hatchet. Now, people will differ about whether we need as big of a government as we've got. And I think that what they're doing, and I talked about this in the video, or there's 3 videos, but one of the videos is that I think that Musk and Trump feel like they have a very short period of time to get a lot of stuff done before the lawsuits come up, or they lose the Republican support, or there's another election in 2 years and the Democrats take over the House or the Senate. They're doing everything they can to cut it as quickly as possible, and then later on build it back. But I think that's their attitude. They just want to move quickly and aggressively. And I think the problem is that the cuts aren't very targeted. Like, for example, I live in Georgia, and we have the CDC here, the Center for Disease Control. Kind of important because they're the ones who are front line when it comes to diseases like COVID or Ebola or some of these terrible diseases. Um, they shouldn't really be cutting the CDC. We live in dangerous times, and I think you want to have a rapid response team from the CDC going to these, they call them hotspots, but they're using a hatchet to go after these bureaucracies, and I'm not so sure that's the best way to do it. I mean, in Social Security, they don't have enough people as it stands right now at the field office level. Now, maybe in Washington they have too many, but they shouldn't be. Right now, people in the field offices are retiring. They don't want to go back to the office. They're not happy with the working conditions. They have fewer people on staff than they did 25 years ago. That's a problem because they're a lot busier than they were 25 years ago. So I'm not so sure cutting with a hatchet is the way to go, but I do understand the logic of we got to move fast and get these cuts in while we still have the ability to do so. So it's kind of a balance, but I don't know. What do you guys think? I'm curious as to what you think about what's going on with Mr. Musk and Mr. Trump and the government and all the things they're doing. I'm sure people have opinions because they voiced them on the YouTube channel. So you're here. Give me your opinion. Life with Paulie says, my disability CDR was supposed to be in November of 24. I received nothing yet. And I went to there. The lady said, most likely there's a delay. Yeah, there's going to be a delay. They're understaffed, overworked. Until they send it to you, don't worry about it. CDR is continuing disability review. And basically what that means is Social Security will send you a form. There's either a short form or a long form. The short form is like 6 or 7 questions. Basically, they ask you, are you working? Have you had any improvement, whatever. The long form asks more detail. And that will determine how you answer that and what evidence they gather. They may request medical information. The adjudicator, same people, who are evaluating your case for, whether you qualify, will make a decision that you should be processed for termination. And you can appeal that. But if you're processed for termination, they will cut you off, and then you have to try to get back on benefits. The problem, as I mentioned before, is if they move to terminate your benefits and you choose to have benefits continue while you wait, no past due benefits, no attorney on contingency. If you choose not to have benefits continue, this process can take a couple of years. You got no money coming in for a couple of years, but you can hire an attorney. Really difficult problem. And I don't know the answer to it, but it's a difficult problem. People making 1P4G says people making over 170 should continue paying into FICA. That would solve a lot. It's also unfair. Let's see if there's anything else. This person. Okay, so what 1P4G is saying is that the wage cap right now is around 170, maybe a little over that. That after that, your wages are not taxed for FICA or Social Security. And, many people call for an increase or elimination of this cap. And that would certainly shore up Social Security's finances. I think, that the bigger, and that's an issue, yes, that needs to be shored up. I think the bigger problem, though, is that we've got to figure out a way, and I don't know how this would happen, but Congress needs to take that money that's being gathered for Social Security and not spend it on other stuff. It's not a piggy bank. They should set that money aside, buy treasury bonds, whatever, and, let that money, of course, treasury bonds is the government paying the government, but, I don't know what they can't really invest in the stock market, but, at least set the money aside so that it is, it's not being used up so that, down the road it's there. Right now, the money is an IOU, and, that doesn't do us a whole lot of good because it's already been spent. Give people in Congress money to spend, they'll spend it. KR says, I call the local office to start trial work period. Will they mail you? They're not going to mail you anything, I don't think. They just will keep an eye on it, but you need to keep your own records of your gross monthly earnings. And remember, 9 months over the trial work period amount in any 5-year period of time is what you're allowed. GLA, I don't know what happens for trouble with that. GJH does not admire the current administration. I think we can say fairly. Sam the Man, I was denied at recon. Is it still possible to submit additional medical information for the upcoming hearing? Yes, it is. You need to. What you got to be careful about is something brand new. So if you have never discussed your diabetes or your shoulder problems, that's when it's problematic to bring it up now. But if you have updated records, absolutely. In fact, you're required to do so. So yeah. Deb here. Deb has always got some very good comments and suggestions for people. So Lisa was the person who said that her disability is coming to an end later this year. I've never heard of a proactive, where they terminate you in advance and say you're going to be terminated as of December of 25, when we're in February of 25. So I don't know what that is. Biol is thankful. Well, I appreciate you for tuning in, and I'm glad to help. Jim says, if you're denied during your CDR, do you recommend contact your representative and ask for help? If you get a CDR, and I think what to translate, if you get a CDR and the Social Security decides to move to terminate benefits, again, the issue you run into is whether you go to your current attorney or the attorney that helped you or somebody new, you're going to have to make a decision within 10 days of getting a notice of termination. 10 days, that's all. You have to decide you're going to go ahead and continue to get benefits paid to you. You have to do that affirmatively. If you do that, which means money comes in for the next couple of years, you won't be able to hire a lawyer on contingency because there'll be no past due benefits. Or you don't do anything in terms of asking for benefits to continue and benefits stop. And at that point, your accrued benefits began during all those months while you're waiting for a hearing. And you could hire a lawyer on contingency. And I've done some of those cases. The question is, does the medical evidence in your case still support a finding of disability? And so if I'm looking at one of these cases, and again, I've done a couple of them, I'm looking at looking at other cases. Just because somebody may have had, let's take heart problems, severe heart problems in 2011, 2012, and got them on disability. Now it's 2025, and they're being, processed for a CDR, and the reason for it is because their heart functioning is improved. Well, I look at those records, and it turns out the heart function is improved. What am I going to argue? So it's just going to depend on what the medical evidence tells me. Paul Harrison, I'm on disability. Besides keep my appointments, take my meds, what else should I do? Keep benefits? I would just make sure you go to the doctor. If you try to work, take a, just really write down what happens. Maybe keep a diary of your pain, a pain diary, your day-to-day activities. There's really not much you can do, to prepare. You just have to, just make sure you have ongoing medical treatment. And again, if you've got a condition that would be something you could diary, like a pain diary, a blood sugar diary, something like that, that would become objective evidence of your disability, then that would be helpful. I have an odd question. Who chooses the 5 diagnoses they want to try to see if you're eligible for disability? I think what, Laura, you're getting at is that many lawyers, myself included, when somebody's applying for disability, I'll ask for a list of all their issues. And in fact, on the application, you list up to 10. You could actually list more. There's extra space, you list more. My feeling is that you want to really focus on the 2 or 3, maybe 4 conditions that are most serious. Now, you can list the other ones, but I think that if you start listing 15 conditions, it's going to be confusing to a judge. So I really focus on, 2, 3, 4. Obviously, your attorney's thought about 5. But I would mention the other ones, but I think you want to really focus on the ones that are most debilitating. And it's unlikely you're going to have 10 conditions that are all equally debilitating. 2 or 3 of them are going to really stand out, and those would I focus on. I think that's what your lawyer is telling you, because otherwise, if you have 15 different things going on, how do you distinguish you know, what condition 7 does versus condition 9. It becomes very hard to track that. Okay. Okay, so Paul's question was, what should he do? He's been approved. What should he do other than with the doctor? And I think that GJH makes a good point. Is, you know, stay off social media, and not that Social Security has active investigators for most cases. It's very rare, in fact. Just be aware. Well, first of all, you shouldn't be, if you've got a serious condition, let's say physical, you shouldn't be going skiing. You shouldn't be playing basketball. You shouldn't be, lifting, big boxes out of your truck. Um, because if somebody should see this, whether it's a nosy neighbor or an investigator for Social Security, you got a big problem. And actually, the nosy neighbor is typically the bigger problem. Um, so I think that, yeah, I think that's legitimate advice. Just be aware and follow your doctor's instructions. You know, when I had sometimes answer this question, people say, "You're telling people to commit fraud." I'm not telling somebody to commit fraud. I'm saying if you can do something, you should try to work. And if you're having a really good day, okay, that's fine. You can have a good day. But if you really have the capacity to lift 45 pounds on a regular basis, and you're approved, let's say you're 48 years old, let's say on something like that, and you regularly go to Home Depot and pick up big, a big container of cement, or 2x4 or something like that, then yeah, that's problematic. And if Social Security should find out about it, they'll move to terminate you. So I think you just want to make sure you adhere to your doctor's limitations and suggestions. Just Joshin Entertainment. Okay. Oh, I get it. Just Joshin. All right. Hello, Just Joshin or Josh. Hello, Jenny. Thank you. You're welcome, Jenny. Jim's last CDR was about 15 years ago. I personally handed over medical records to the local office. Seemed to work. 15 years is an eternity in the Social Security world. So, some people, I don't think it's a mistake to get them your updated medical records, at a CDR. Others disagree, but I don't think it's a problem to do that at all. I mean, the more information they have, especially if you've got ongoing treatment and the doctor is supportive, I think the better. Okay. Josh's keyboard sucks. Okay. Okay. So he got a decision where he was approved for SSI. The onset date for his disability was after his date last insured for SSDI. You can appeal that. You want to think about that, but you can certainly appeal that. If it's just a couple of months, after the DLI, maybe you can find evidence, from a doctor to say that your condition was at a disabling level as of your date last insured. I would take a long look at appealing that, because SSI the real problem with SSI is it traps you in poverty, because if you do work at all, it counts against you. SSDI is a much more robust program, and I think it's designed to encourage people to go back to work. So I'm not a big fan of SSI. So, it's a decision you got to make. It's a risk you got to consider, but, I think it's what you should definitely look at. Okay. If you sign an agreement with the state to receive workers' comp settlement, and you say you won't file for Social Security for 3 years, can you get your DLI extended because you're unaware of the consequences? No, can't do it. That's a great question, by the way. But no, you can't get your DLI extended. It's a calculation based on your earnings and the time you worked. Paul says, thanks for the heads up. You're welcome. Oh, Paul to GLH. Yes, I agree. As far as this is the person who is approved for SSI, not SSDI, it's a tough call. I mean, I'm not a fan of SSI, but again, it's not my life. It's not, my livelihood. You could certainly argue that if you got approved for SSI and you take it to appeal, first of all, the appeals council might not take it anyway. And I think here's what I would do. I would probably tell you to have a appeals counsel specialist look at it, and give you an opinion as to whether they think it's got a chance for success. You got 60 days to do that. If you email me, ssdanswers123@gmail, I'll give you the names of a couple of people who do this kind of work. I don't do it very much anymore, but there are a couple of people I know that do nothing but appeals work. See what they say. See what they say, and make an opinion, make a decision based on that. Because I'd much rather see you on SSDI than SSI. Is Medicare? I don't know. I don't know. I honestly don't know. I do not know much about Medicare, so I don't want to give you a wrong answer. I don't know. Life with Polly. On disability for mental issues, the possibility of getting better. Okay, I think we've already answered this. Widowmaker, I think you want to focus on the physical when you possibly can. That's okay. Worry about SSI screwing up the current Medicaid. Yeah, because you get, if you're an SSI, because it's for low income people, you're going to get Medicaid, you're going to get SNAP benefits, and so forth. This is a tough question. Again, like I said, what I would do is I would run it by an appeals specialist just to see if you would have a chance at it, because they're only going to take cases that's a strong likelihood of their winning. Then it would go back to a judge. And again, if you've already won once, is it likely you're going to be turned down totally again? I don't think so. But again, I think you want to run it by an appeals specialist and then think long and hard about whether you're willing to bear that risk. Vinny Boy had a 14-minute hearing with a vocational expert question. Lawyers still went great. The ALJ was asked for a supplemental hearing. The only reason I can think that may have happened is they did change the look back. Well, there are two reasons I think that could have happened. I should say three reasons. One is the judge realized he didn't ask enough questions and wants to remedy that. Number two is that when they changed the look back from 15 years to 5 years, some of the vocational questions, became moot. The judge asked questions about past work that was really not relevant anymore, because it's a 5-year look back, not a 15-year look back. And the third reason is that under some new laws, vocational witness testimony has to be more carefully authenticated, and the judge has to confirm the vocational witness's sources for giving answers. Practically, the same things happen at the hearing. The judge knows what the vocational witness is going to answer, and they ask questions accordingly. But the vocational witness now has to be asked these questions literally off a script about how he or she came up with his numbers and the sources they use to make it all legal. So that may be what's going on. Your lawyer could tell you better, but my guess would be it's more of a technical thing than anything else. They told me to scan my documents, give them a week, and understand. Again, if you have a claims specialist and they wanted your records, and they said give you a week, give them 3 weeks, give them 4 weeks, because very little happens in a week in the Social Security world. Stacy, mine yours. You're very welcome. Mo3, 47, got a CDR of MS. Got an MRI 5 years ago. I've been a doctor several years. How would likely be approved? Obviously, MS does not spontaneously disappear. On the other hand, it would be helpful to have a new MRI that shows more lesions, more progression. That would probably satisfy the Social Security that you're not getting significantly better. But, the fact that you've got a permanent condition that is progressive, I'd be surprised if they would move to termination. Does the amount of money KP asks that you earn while waiting on SSDI approval include your spouse's income? No, it's just your income. Just your income. Okay, Foxtrot uniform. I see what you are doing with your first letter of each word there, but okay. No such thing as permanent SSDI exists. The closest thing living into your preferred time range SSD converts rate, which I'll agree. I would agree with that. You cannot assume there's anything permanent about Social Security. Randy, does everyone automatically go through DS with included trip to the doctor? It is not. Everybody goes through the DDS. Yes, the state agency considers every case. Does not always mean you're going to go to a consultative doctor. I'd say 80% of the time it does, but it's not required. But every case has got to be evaluated by a state agency. That is correct. Okay. I think Deb is answering correctly. If you've got enough insurance, your spouse's income does not come into play. Correct. First name, last name. Would it be better to do a mental consult in person or over telehealth? I would probably, if you can do it in person, do it in person. That's probably going to be better just because you'll establish more of a connection with the examiner, but as opposed to just being a phone call. But I think both of them are legitimate ways to see a doctor. But if you can do it in person, that's probably, if you have your choice, do it in person. I'm just white, 59, 100% VA civil vet with stage 4 sarcoidosis, emphysema. Conditions, consistent medical history, lung disease, lung conditions, hard to improve. They are. I would look at the listing. Let me give you that number here. The listings for pulmonary are going to be at listing 3. I will give you a link here. And I would look at the listing, and there's going to be tables that talk about pulmonary function testing and your results there. I would say, again, you've got a serious condition there. I would see if your pulmonologist would say you meet a listing or equal a listing. In the alternative, you could certainly make an argument that your capacity to work would be greatly reduced by your, pulmonary dysfunction. But I think that, long medical history, your age, again, just as long as you're limited to light work or less, you're golden. So I think you got a good case. Miss Crystal says, okay, thank you, Miss Crystal. Much appreciated. Ellie Brown says, good evening, all. Mr. Gumballs, March 13th will be 1 year as my case of a recon. It's long, but not unheard of to be in recon for a year. Not atypical, but not typical. I look fancy tonight. Yeah, actually, and again, I always give these stories nobody really cares about, but my wife and I decided to take a walk the dog. We have, Sadie, the golden doodle, 75-pound golden doodle. And so she's like, let's walk to, there's a pizza place a couple miles from here. And, she knows I like pizza. It's really good, actually. So we walked up there and we had a couple slices of pizza. We walked back. And so we left, at 6, I come on at 8:30. We left like at 6:30. And, we got back, and I literally got back at 8. I got back at 8:18. I was taking a shower because I needed to take a shower because I was discussing because we just had this long walk. And so I came down here, and I was in a t-shirt, and I keep a shirt down here because I do my videos down here. And so I just usually change into this shirt. So I'm like, okay, I'll just put this shirt on. I made the mistake one time of wearing a shirt with like very thin lines, and there's an artifact that will happen when you do that with many cameras. And so you don't want to do that. So I just discovered that a plain blue shirt is the best way to go for videos. A white shirt is fine, but it gets a little washed out. So plain blue shirt is better than one with a pattern because, again, you get these artifacts that, like jumping up and down. And so it just doesn't look as good. So this is my video shirt, that I have loosed for the last, few weeks is what I've had come down here. And I'll put it on for an hour and I'll do my videos. So that's why I look so fancy tonight. All right. No Scott says, don't be shy. Put your pressing questions in the chat. I haven't seen any questions from you, No Sky, so, but I agree with you. Okay. First, okay, Deb says, one of my former professions was mental health. Doing a proper assessment, in my opinion, always on a person to get the whole picture, watch the eyes. I would agree. I think Deb is right on target with that. Michael Desjardins been diagnosed with chronic heart problems with ejection fraction 20% yes, denied in my first try, filing an appeal, but is concerned about his doctors told me it should have arrived. Yeah, you're at listing level if you're at 25% or below, so you clearly should be approved. But doesn't mean you're going to be approved. But I think you've got a good case at that with that level of ejection fraction. Okay, Elle says Blue Sky had asked about getting your bank account information to them, and I'll take your word for that. I've never seen that. I mean, I've got my own online account at Social Security where I can check my earnings and all that kind of stuff, but I've never had to enter bank account information for disability, obviously. So I don't know, but I'm assuming that's correct. Any new laws pertaining to 2025? Yeah, I mean, the one I talked about a couple weeks ago was this emergency message, which basically said that experienced adjudicators can grant fully favorables on cases with physical impairments if there's not enough medical specialists available. That's one big thing. There's going to be more stuff coming down, but that's the only thing that jumps up. And then the whole vocational witness thing, where vocational witnesses now have to be questioned more thoroughly about their methodology at hearings, and that's kind of new. But those are the two main things I would tell you that are most new. Why would a judge deny a person's claim when you're over 50? Well, obviously, one would be if you could do light work. So if you've got capacity to work, then you wouldn't grid out. If you have a non-exertional impairment, like mental health or whatever, then the grids don't apply at all, and you've got to prove that you can't do any kind of work at all. So maybe that over 50, the grids don't apply because you have a non-exertional impairment or non-physical impairment. The judge could find that you could do past relevant work. That's called a step 4 denial, because step 4, the sequential evaluation process, asks if you can do past work. So if you can do past work, that would be a reason to deny you. A judge could find you not believable, not credible at all, and just discount everything you're saying. A judge could find that you've got drug and alcohol issues that are material and a material factor to your disability, that if you were not using substances, then you would not be disabled. That could be a reason for it. So any number of reasons, but obviously the main thing would be if a judge does not find the evidence persuasive enough, that you've got a significant medical problem to get you past even having a severe impairment, which is early on in that process, a 5-step process. But usually it's because the person has capacity to work that would not allow the grid rules to be an approval. So if I have a person over 50 who's denied, normally it's because the judge finds they could do light work or they could do past relevant work, with the main reasons that you would be denied over 50. Lovely Me says, I give great information. Well, thank you. I appreciate that, Lovely Me. I try. I've been doing this a long time, and you're bound to pick something up. But I think I've got a pretty good clue as to what's going on. Brian Murphy is a herniated disc and bulging neck disc, stenosis, turned down twice. Well, again, you don't get approved based on a diagnosis. You get approved based on what the effect of those things would be. And also your age is a factor. So if you're 25 years old, that's going to make it more difficult than if you were 56 or 57. But again, having a herniated or a bulging disc does not make you disabled if it doesn't impair your function. So you got to have that other part of the equation. How does your function get impaired? Laura says they're trying to get more applications pushed through. I think they're trying to take the backlog down. There is definitely some effort there. I think that is a big problem with the backlog, and I think that that's something they're going to try to address. And the nice thing about that is a numbers problem, and there seems to be a lot of focus on numbers and in this administration. So maybe that'll be a positive. Who knows? Had a great see about 45 minutes. Got a call from determination the day before to remind me, and that's not that unusual, but it's nice when that happens. And I'm glad you had a good experience with your CE. I would encourage you to get a copy of the report so you can look at it and make sure it's accurate. Just Joshua is the person who was approved for SSI, not SSDI. Is information pertaining to mental health issues from high school age records worth putting forward in spite of long gap of coverage in adult years? I think so. I mean, I think that again, it's probably not going to be determinative of your whether you become disabled, you're found disabled or not. It does give interesting history, and if you can show that you had this problem going back, 20 years ago, and that you didn't get treatment because of financial reasons, and now you've got treatment again, and now they're seeing the same issues that were going on 20 years ago are back. I think that's relevant. Yeah, I would. I mean, you're in a situation where you got to make a decision about whether you want to appeal a favorable decision on the SSI. So again, part of that equation is going to be, do these records, will they make a difference? Would that be enough to push you over the edge to get you pushed back to before your date last insured? That's the way I would look at this. Okay, so Andrea had a great CE, and she said that she was treated very well, and I'm glad for you. It doesn't always happen that way, but I'm glad it did happen for you. We had John Foster on a few weeks ago, consultative doctor, and I can tell you from talking to him, I know some people are not going to be happy with his reports because not every report's going in your favor. But I mean, talking to John Foster, I get the sense that he wants to do a good job and does it thoroughly. Not all CE doctors are like that. So, you hopefully get somebody who's going to give you a fair shake. That's really all you can hope for. Okay, and so Deb is talking to Michael, who said he's 59, I think, and has, heart issues, was diagnosed with ejection fraction of 25%, and was denied. Again, it sounds like a pretty good case to me. But Deb points out that the ejection fraction is one factor, although again, it's listing level by definition. If you're 25% or below, it's listing level, I believe. And that what is the formal diagnosis, and prognosis, but those are factors there. My guess would be that if your heart condition is that serious and they turned you down, it's because they didn't get all the medical records, or you had a really lazy adjudicator. That would be my guess. I just find it hard to believe that a person with that serious of a heart problem would not get approved at initial. The curious mind of AI. 53-year-old who retired, 25 years in corrections, 8 years for playing, rapid decline with chronic low back pain, range of motion. Is this common? Medical exam was last Saturday. It was range of motion only. Okay. I think that a consultative doctor should do more than range of motion, in my opinion. There's other tests that should be given. This is, again, one where, if I was going to be objecting to a report because I felt it was not helpful to me, one of the things would be to say range of motion is one of many tests, and this does not tell the full picture. And therefore, this report should be given very little, if any, weight. But again, if the report comes back and says you are, disabled, then you may want to just say, okay, and take it. Okay, we're talking about the paper trail. Yeah, I think if you need older records, you want to establish a paper trail. Johnny Doster. Not going to stay on long, going back to work tomorrow. Okay. Well, Johnny, good to see you. Thank you for checking in. I know you're here most weeks, and I appreciate that. Freedom 64. I was approved finally last year after 3 long years. Absolutely. I turned 60. My paperwork says to be reviewed in 5 to 7. You think they will review? You're not going to get reviewed. I mean, you're 60 years old. They're not going to review you. I just think it's so unlikely. It could be, but I mean, a 5 to 7 also says that this is a case where medical improvement is not expected. In 5 years, you'll be 65. You'll be close to full retirement age. They're not going to review you. Just don't think they will. You were sent to an ear exam, I guess as part of your, let's see, Go back to Curious Mind. 53-year-old, and you had a medical exam. Even though you got a bad back problem, they sent you an ear exam. Hearing issues are not part. I cannot explain that other than somebody obviously thought you had a hearing problem and they sent you to a ear, nose, and throat doctor. This is Social Security logic. It's just somebody screwed up. That's all I can tell you. Okay, Tracy Martin's son is 22, diagnosed with autism at 18, suffering from contamination OCD since September 1, literally overnight after having COVID. In August, filed November 22, received her knowledge June 24, recon, still waiting, you're still waiting. Again, June of 24 is, not a year. It hasn't been a year. You should be getting close, but this is one where we may want to do a congressional inquiry, try to get moving faster. But you're not out of the realm of normal when it comes to the time frame, unfortunately. Hello, Ruth. How are you doing? Ruth is a longtime listener. Ruth just purchased my book, which I appreciate very much. Thank you, Ruth. And it went out. I made sure it went out today, by the way. Should you provide your DDS worker with your attendance reports, payroll records that show the total amount of time you took off? I think that would be very helpful. That's very good evidence. It's objective evidence, and it does show that you are, you have some limitations as far as reliability, which is the heart of what Social Security is about. So absolutely, I would do that. Should you mail them? It's over a reasonable fax amount. I probably would tell you, or break it up into multiple fax packages, 50, 60 pages each. You could mail it. I mean, I would, if there's any way possible to check to make sure they got it, because you mail it and it goes into a black hole. But if you could get it to them by mail, that's probably not a bad thing to do. But faxing is obviously a easier way to do it. But if you have to fax it, break it up into 50, 75 pages and put the barcode on each part of it, and they'll put it all together. But probably mailing it wouldn't be a bad thing here. They say I rock. Okay, well, that's a good thing. I mean, you've never heard me sing, and you never will. If you heard me sing, you know that I do not rock in that regard. And I play guitar, you would know that my guitar skills are not very good either. Although I took some lessons, I could, when I was at my best, you could understand what I was trying to play. You could recognize the song, but that was about it. I just, some people have talents in music, and I don't, unfortunately. My son is played the drums. He was good. My daughter has got long fingers, played guitar. I just don't have the musical skill. So no rocking in that regard. No clickbait. Pure SSA contact, devoid of politics and disinformation, broadcast marks safe. I don't ever comment about political things because, you alienate half your audience when you do. And quite frankly, I'm kind of moderate. I mean, I don't really feel like I'm an extreme on either. I know people are extreme on both sides, and I think that you have to listen. I listen to news sources from all sides, and I make my own mind up on some issues. I go one way, and some issues I go another. And at the end of the day, I just have to do what I think is right for myself, my clients, my country, and that's the way I look at it. But I think anybody who is an extreme on anything, that's problematic to me. So, and when I talk to you all, I'm trying to give you information. I'm not trying to persuade you, because I have it's not my role. My role is to say, we have this coming up. This is what's going to happen with this president. This is how to prepare for it. Because I don't care who's in office, I want to win my clients' cases. And, that's my bottom line. That's my bottom line. But thank you very much, GC Styles. It's 24 Styles. I appreciate that. Blue City Garage. I filed almost 2 years ago. And I ran out of insurance while waiting in limbo. Yeah, you very possibly will. CDMR, 2-year-old CT and MRI. I would get new ones if you can while you still have insurance. But this is a real problem. I mean, these cases are taking 2 to 3 years. And then you get to a hearing and the judge says, you haven't been to the doctor. I'm like, well, because my case has been going on for 3 years. I ran out of insurance. No good solution to that. It's a real issue. Real issue. All right, George says lies. I'm not sure what kind of lies we're talking about, but okay. That's me. Okay. Hello, George. How are you doing? Vincent Costanzo. I'm 62, waiting for SSDI appeal reconsideration. Going to file retirement without prejudice. I'm an attorney in the case. I would talk to your attorney about it. I mean, your attorney's obligation is to do what's right for you. And if filing for retirement benefits you, it may reduce your past due benefits. Won't eliminate them. It'll reduce them. But that's not a factor. I will tell you as an attorney, I've been doing this a long time, and ethically, we have to do what's right for our client, even if it means a lower fee for us. So, if it makes sense, economically for you to do it, and if you're willing to realize if you take early retirement and you get denied Social Security, you're stuck at the early retirement, as opposed to waiting till closer to full retirement. And if you lose, you're not stuck. You can get the later retirement. So that's the big risk. If you take early retirement and you lose, you're stuck at that lower number. But at 62, are you really going to lose? That's a high percentage of winning. But I would talk to your lawyer and discuss the pros and cons. But your lawyer should not discuss with you, the fact that there will be a lower fee for him. That is, or her, that is not a relevant factor here. Life with Polly. Okay, I received disability from mental, have stents, take heart meds, infarction rate of 35%, they would put pacemaker on heart attack, 47, I'm 50. Again, I would tell you that your chances of being reviewed and terminated are really low with all that, because you've got a serious physical problem as well as mental health problems. And I think that, you are a deserving claimant, it appears, and unlikely to be reviewed, and unlikely to be terminated if you are reviewed. C is consultative evaluation, pricey joy. Social Security, many times to develop the record, will send you out for what is called a consultative evaluation. That is where one of their doctors or a doctor on a panel will evaluate you and offer an opinion about your functional limitations. It's, at one point it was kind of okay, we do this because we want to make sure that everybody gets some medical record review. But if you had treating, doctors who had seen you for a long time and had also given an opinion, it used to be the treating source rule said that your treating doctor's opinions carried a lot more weight than the consultative. They got rid of the treating source rule, which is ridiculous in my opinion. And so now, in theory, a judge could deny you based on the consultative evaluation. Doesn't happen very much, very rare, but that's the issue. But you have to go to them. And as if you've seen from some of the other comments, the physical ones in particular can be problematic at times because they don't, the doctors don't spend a lot of time with you, and sometimes they're downright inappropriate. My experience is the psychological consultatives are usually a little more useful and valuable. True or false for the line of the adjudicator? It's partially true. This emergency message that I've talked about for a couple of weeks now basically says that if they don't have a medical specialist available, and there's probably metrics on that in terms of how many that you need in a particular office, and you have a case that involves a physical limitation and there's no change in the onset date, an adjudicator with a certain amount of experience and training can approve the case without going through the medical to speed things up. And to that extent, yes, that is one of the programs that is designed to get rid of the backlog. Could not have said it better myself. Pricey joy. Focus on how your condition affects your ability to work. Exactly. Not a list of woes. Exactly. Your complaints, your diagnosis, it's all not relevant. What's relevant is, the effect of your medical problem on your capacity for work. Okay, I think other people have answered that. Jenny says yes. Pricey joy, yes. You're welcome. Chat some answer. I want to appeal mental health. Okay. All right, Sheridan, we've got, by the way, about 5 more minutes. So I'll try to zoom through a few more of these. Charities of the Appeals Council with a free representative that was replaced with a law firm and contingency, filed new claims. Okay, so you got to get that straightened out because you can't really have a new claim and also a case with the Appeals Council at the same time. So you got to figure out who your lawyer is and get this straightened out because that's, without going into more detail, that's going to be a problem. Something's going to happen. One of them's going to get dismissed, and you want to choose which one you want to get dismissed. Younger claimant, I think this is addressed to the gentleman who was 25 who just got denied, and GC is saying that your Department of Vocational Rehab might be a place to go, and I would agree. Allie was denied for SSI, then approved second time at work in the non-medical review. 25 to have a history of SA since you were 12. So I'm not sure if you're saying that you're waiting for the non-medical review to be done, but you're getting close to being, at the home stretch there. So if they've approved you, that's a good thing. Obviously. Risk and back pay. Maybe I would talk to your lawyer about this, Charity. You got to get this straightened out. Retirement. Okay, so that's answering the question about retirement. Let me see if I can. Right. If you have representative, you don't want to have more than, you can't have more than one representative. I'd start with the person who's doing the appeals council work, and just see what they can find out, and then try to figure out how this new application got filed and what needs to be done about it. It's something's got to be fixed. But yeah, I would talk to the person who's handling the appeal. See, I don't know if I agree. I've not had judges recently tell me that because someone has unemployment, they're saying they're willing to try to work, that is determinative that they can work. So that's been my experience. This is more of a retirement question, but I believe the answer would be yes. You get work credits no matter how old you are. Okay, a couple more questions. Chiral adjustments. Chiropractic is not considered to be an acceptable medical source. So, the doctor's notes and conclusions and diagnoses won't be given much weight. The fact that you went to a chiropractor or your son went to a chiropractor is going to show that it was treatment sought, and the treatment can be explained what the chiropractor did, and if it provided benefit or didn't provide benefit, that's all part of the record. But chiropractic, this evaluations of someone's capacity for work are not given any weight. Okay, it's an interesting question. I have a job interview for an SSDI attorney position. Any last minute tips? So you're looking to be an attorney to do, this type of work. I'd say, obviously you want to educate yourself as much as you possibly can about the process. And obviously videos in this live stream hopefully give you an idea. I think that, what helped me the most when I started out was understanding the big picture. And that is that this is about work capacity and about identifying specific things in a medical record that will impact a client's work capacity. And just seeing the big picture there and understanding the theories of disability, understand the grid rules, understand the listings, understand functional capacity. And I think if you understand the big picture and you basically say, that the goal, and really what I do honestly is when I get a medical record, I really dig into it really hard to, and abstract the record to really find out what's going on, to create a narrative. If I had to tell you the one thing that makes me effective, I believe, as an attorney is I'm a big believer in identifying a narrative for my client. This is my client's story. This is what he or she has gone through. And this is the medical story. And this is what this means in terms of their functional capacity. That really allows you to talk to the judge while you're telling a story. You're giving a narrative out. That makes you, I think, a very effective advocate, because you are an advocate for your client. as opposed to just throwing out a bunch of medical evidence. Here, he has an MRI here and a CT there. You want to tell the story. So I think if you're applying for a job, you want to, let the person you're talking to understand that, you recognize that this is about telling a narrative, about telling somebody's story that, in that 45-minute hearing, you're distilling maybe the last 5 or 6 years of that person's life into a story that can be persuasive and credible and believable and truthful. And I think that's really what you want to do as a disability attorney to be effective at it, to know the big picture, and that you show that you care for your clients, that you really want to help them. Deserving clients. People say, "What do you do?" Like I'll see these on these online. What do you do in 15 words? I help deserving disability claimants, apply or win disability benefits from the Social Security Administration. It's telling that story. So that's what I would tell you. It's just understand the technical part, the big picture, and but be able to tell a story. Okay. Charity, thank you very much. Okay, thank you, Charity. I appreciate that very much. Okay. Okay, a couple more questions, and I'm going to end it. I've got a hearing tomorrow morning, so I got to get my sleep. Would I need a diary as well if I've been an SSD since 2009? Condition worsened back then, like 80% worse. I think it's always good to have a diary in case you are reviewed, and even if it's once every week, once every 2 weeks, you make a note in there. I would do it. Okay, last question is going to be Dan Nav. I'm 55 with cervical stenosis, 34 years on the job. That's going to help you. Having a long work history. Applied a year ago, SSDI. I'm in step 4 or 5 initial application. I was told something that I would hear something in the next 15 to 30 days. I think that you may or may not hear anything the next 30 to 35 days or 15 to 30 days. It's been a year, so you should be getting close. If you don't hear anything next 15 to 30 days, I would definitely contact your U.S. Senator, ask for a congressional inquiry. With the cervical stenosis, realize at 55, now you're 55, at 54, you would have to meet a sedentary grid and say you're limited to sedentary work. So, focus on how much you can lift and carry, sit and stand, things like that. Certainly at 55, you can win on grids if you're limited to light work. So, you might think about, would you be willing to change your onset date to get a fully favorable decision? But I think you just want to really focus on the functional issues that arise from your medical problem. And hopefully you will get a decision. Don't be discouraged if it's denied. You should appeal it. Again, at 55, I think it's always worth appealing. And hopefully you'll get a favorable decision now. But if not, it may be a year and a half, 2 years from now, but you eventually hopefully will win. So that's my thought. All right, I'm going to go ahead and close this off right now. It is now 10:34, so I've been at this for just over 2 hours. As always, I greatly appreciate everybody who's taken time out of their Wednesday to join me, and I will see you next Wednesday. Again, I've got some guests lined up. I got a judge who's going to come on, a retired judge. I've got another attorney friend of mine who's going to come on. We had last week we had Adriana, who's an appeals attorney. That was a lot of fun. I learned a lot from her. So I'm going to have some different people on, but of course we're always going to be here to answer your questions. And again, please, if you find this useful, I'll put this up here one more time. Leave me a nice review and say something other than just the stars. I would appreciate that. And then, but if you do want a case evaluation, that's where you would get one. So I appreciate that, and I hope to hear from anybody who needs a case evaluation. Let me know. But otherwise, have a great week. I'll see you all next Wednesday. Take care.